I'm attorney Donald Sienkiewicz of the Estate Preservation and Planning Law Office. Lawyers often talk about estate planning as if there's only one estate to worry about, but today I'm going to tell you about the 5 estates that you may need to plan for. Nearly everyone who dies leaves behind multiple estates or virtual buckets of money and other assets that the law places in several different categories with different rules about how they are dealt with upon your death. The first, and often the largest, is your non-probate estate. This includes assets that you own in one of 3 ways. The first category of non-probate assets are those that you own jointly with someone else who has rights of survivorship. Common examples of this for couples are your home, your automobiles, and checking accounts. These assets pass immediately upon your death to the surviving joint owner or owners by operation of law. That means no judge has to bang a gavel and no lawyer has to generate a piece of paper. The surviving joint tenant will eventually have to obtain a death certificate to prove that you have, in fact, died before he or she can deal with the property alone. The second category of non-probate assets are designated beneficiary accounts. The most common examples of this are retirement accounts like 401ks, 403bs, and IRAs, life insurance policies, and annuities. By federal law and the contract with the company who holds the funds, these assets go to your designated beneficiary upon your death. Again, all he or she has to do is present a death certificate to the insurance company or custodian of the funds. No lawyers or courts are involved. The third category of non-probate assets are financial accounts registered transfer on death, payable on death, or sometimes in trust for a person you've designated. Account ownership forms often abbreviate these as TOD, POD, or ITF. Checking and brokerage accounts can be held this way in most states. Just like the first 2 types of non-probate assets, all that the beneficiary has to do is present a death certificate to the financial institution. The big takeaway point here is that none of these assets is controlled by what you say in your will, because none of them is under the jurisdiction of the probate court. The second estate that almost everyone leaves behind is, you guessed it, your probate estate. This includes any property you owned in your sole name upon your death. What happens to it is determined by your will, as long as your will is clear and nobody fights about it. If you died without a will, or nobody could find your will, the probate court will decide what happens to these assets based on estate intestacy law. If you created a trust, then you also have a third bucket of assets, your trust estate, composed of all the assets that you put into your trust while you were alive. Often, assets in your probate estate can be directed into your trust estate upon your death, under the supervision of the probate court, if you also created a pour-over will. Next, if you own a business in the form of a corporate entity like an LLC or corporation, the right to control of and economic benefits from that business are a 4th bucket of assets that need to be considered. What happens to them may be determined by the operating agreement or bylaws of the company, by your will, or by your trust. Finally, all 4 of these virtual buckets of assets make up the 5th estate, what the IRS and state taxing authorities call your taxable estate. Yes, that includes life insurance proceeds, unless you've set up a special trust. If your taxable estate exceeds certain minimum amounts, estate taxes to the state or federal government will be due. In my next video, I'll illustrate these concepts with a hypothetical couple, John and Janet.